Hi, it's Tanya Bryant with Crow & Dunleavy's Labor and Employment Group. Today we are taking a break from all things COVID to discuss last Monday's groundbreaking ruling from the United States Supreme Court. As I'm sure you've heard, SCOTUS ruled that federal law protects LGBTQ employees from discrimination. There's a lot to digest, so my recap will hit on the high points. How the cases made their way to the Supreme Court, how the votes came down, what some of the arguments were, and what this decision means for Oklahoma employers. Let's begin with the three cases involved in this decision. So the lead case was Gerald Bostock versus Clayton County, Georgia. Mr. Bostock was fired from his job in Georgia as a child welfare advocate for unbecoming conduct shortly after joining a gay softball league. The second case was Altitude Express versus Donald Zarda. Mr. Zarda, a New York skydiving instructor, was fired days after he told co-workers that he was gay. The third case was RG and GR Harris Funeral Homes versus EEOC. In this case, Amy Stevens was a Michigan funeral home worker who was fired after she told her employer she intended to transition to become a woman after 6 years on the job as a man. Sadly, Ms. Stevens and Mr. Zarda both passed away while their cases were pending, and so they did not get to see this watershed case that will likely be associated with their names for many years to come. The reason these cases made it to the Supreme Court was because of a split between the Circuit Courts of Appeal. The Second Circuit Court of Appeals, the Zarda case, and the Sixth Circuit Court of Appeals, the Stevens case, held that Title VII does cover, meaning does prohibit discrimination based on sexual orientation and gender identity. And so Mr. Zarda and Ms. Stevens were able to proceed with their cases. However, on the other side, the 11th Circuit Court of Appeals expressly held that Title VII does not prohibit firing someone because the individual is gay. And therefore, Mr. Bostock was not able to proceed with his case. So all three cases made it up together to the United States Supreme Court, and the court resolved the conflict on Monday. The court held that Title VII of the Civil Rights Act of 1964 prohibits discrimination against individuals who are gay or transgender. For those of you who are interested in how the votes came down, this was a 3-6 majority vote with two of the conservative justices, Justice Neil Gorsuch, who wrote the opinion, and Chief Justice John Roberts, who joined the court's 4 liberal justices to find that Title VII's ban on sex discrimination encompasses sexual orientation and gender identity. The majority opinion is 33 pages long, and the dissents by Justice Alito and Thomas together totaled 54 pages, and Justice Kavanaugh's dissent was 28 pages. The timing of this decision is notable given that we're in the middle of a COVID-19 pandemic, civil rights protests all around the nation, and June is LGBTQ Pride Month. This is indeed an historic moment for the country. So let's talk about the rationale for the court's decision. The court said its opinion was a straightforward rule. The fundamental premise is that intentional discrimination under Title VII occurs if an employer intentionally relies in part on an individual's sex in taking an adverse employment action. Put differently, as the court explained, if changing an employee's sex would have yielded a different choice or a different action by the employer, Title VII has been violated. The individual's sex doesn't have to be the sole or primary factor. If the decision was made in part because of the individual's sex, that is enough for a violation of the law. What's really interesting is that the majority acknowledges that sexual orientation and gender identity are distinct concepts from sex. So the court isn't saying that sexual orientation and transgender status are the same as sex-based discrimination. But what the majority does say is that homosexuality, and this is a quote, homosexuality and transgender status are inextricably bound up with sex. Essentially, an employer cannot take action against an employee based on sexual orientation or gender identity without discriminating because of sex. So you can't have one without the other. Because these concepts are so inextricably bound, the court said, quote, "An employer who fires an individual for being homosexual or transgender fires that person for traits or actions it would not have questioned in members of a different sex. Sex plays a necessary and undisguisable role in the decision, exactly what Title VII forbids," end quote. The employers had several arguments. We don't have time for all of them, but one of the arguments I thought was significant was that Title VII was written back in 1964, and Congress would not have contemplated affording protection to homosexual and transgender individuals. The court, however, rejected that argument. The court responded by saying, look, there is no need to resort to legislative history when there is no ambiguity in the terms. The court looked at the plain and obvious definitions of the principal terms in Title VII. Terms like sex, discrimination, individual, and phrases like because of. The majority said, quote, "The limits of the drafter's imagination supply no reason to ignore the law's demands. Only the written word is the law, and all persons are entitled to its benefit," end quote. Now, the dissent, on the other hand, said, look, the court is legislating. The court is not interpreting a statute, even though that's what it's claiming to do. The court is legislating because sexual orientation and gender identity are not concepts that are enumerated in Title VII's prohibited list. Therefore, the dissent stated, if you're going to add those concepts, which the dissent points out the majority acknowledged are distinct concepts from sex, the court shouldn't be the one to do that. It should be Congress. The real question, according to the dissent, isn't whether discrimination based on these concepts should be prohibited. The question is whether Congress did prohibit them back in 1964 when it drafted Title VII. But the dissent is not the law. The law now is that Title VII prohibits adverse employment actions taken against employees based upon their sexual orientation or gender identity. So what does this decision mean for Oklahoma employers? Although there are a couple of local ordinances prohibiting discrimination in employment for gay and transgender employees, Norman, Oklahoma for one, Oklahoma does not have a statewide ban prohibiting such discrimination. Title VII, which is federal law, the law of the land, applies to Oklahoma employers with 15 or more employees. There are many employers who already have written policies and procedures in place that prohibit discrimination based on sexual orientation and gender identity. But those employers who have not yet implemented these protections on their own should do so immediately. Anti-discrimination policy should be revised, and anti-discrimination and anti-harassment training should include a discussion on the prohibition of discrimination, of harassment of gay and transgender employees. It's not enough to just have written policies. Employers should take the time when training to explain what the company expects from its employees and managers. The employer's complaint procedure should be openly communicated to all employees. Just as an employee can lodge a complaint of being harassed because of their age or because of their national origin or some other protected category, now an employee who is gay or transgender can do the same. And the employer is obligated to promptly and thoroughly investigate any complaints. It should be said that employers who promote and welcome inclusiveness in their workplace can achieve a respectful, diverse workplace where everyone's differences are embraced. Whether your company is already ahead of the curve on these developments, or whether your company is going to be making rapid changes to catch up with this news, it is truly an historic moment in employment law history. As always, the lawyers in Crow and Dunleavy's Labor and Employment Group will continue to update you on any new developments and are ready to assist employers as they face continued changes and developments in employment law. Until next time, stay safe, everyone.